presentation. I'm going to ask everybody to mute themselves when they're not speaking, which is now, and I can, there, thank you. Okay, so I've titled this UN CRPD from a survivors of psychiatry perspective. I consider myself a survivor of psychiatry, survivor of psychiatric institutionalization, and this is a distinct and meaningful identity. It's not the same as being a user of psychiatry. For me, it's not the same exactly as being a person with psychosocial disability, although we have at times used the term people with psychosocial disabilities as a sort of general designation, meaning the same as users and survivors of psychiatry, and it all gets kind of mixed up. But my particular perspective is as a survivor of psychiatric violence, psychiatric institutionalization. So I'm gonna go ahead and start. So some of you may have some knowledge already about the CRPD and others may not, or may have very little. So I'm gonna just say, I'll just go through this and I'll invite you to put questions in the chat. If there's anything that's a real urgent need to know that I'm not answering, you can put your hand up even while I'm speaking and just get my attention on that. So we don't just keep going and something is getting lost. So the Convention on the Rights of Persons with Disabilities is international law. It's considered a core UN human rights treaty. Means it's I mean, I don't know, the designation as a core treaty usually generally means that it has a treaty monitoring body that's a committee of experts that meets periodically in Geneva. And this is called the Committee on the Rights of Persons with Disabilities. The committee reviews each state party periodically. States parties, that means countries that have ratified the convention. By ratifying, they become legally bound to uphold the convention, to put it into practice, and it's binding on them under international law. So how they deal with that in their own domestic legal system, whether you can actually go into your national court and make a complaint saying my rights under the CRPD are violated, that can vary from country to country. I know in some of the countries represented here, that is very much available, like Mexico. If the US ever ratified the CRPD, it wouldn't because of the way we treat human rights treaties here. So the Committee on the Rights of Persons with Disabilities, they review the performance of each country that has ratified the treaty, and they consider how well it's doing in actually upholding its obligations. They issue concluding observations, telling the country, sometimes they'll say what they're doing right, often they say what they're doing wrong, and making recommendations for improvement. They also issue general comments and guidelines when there are some general issues, some overall issues that are common to all countries. And sometimes it's an issue where there might have been misinterpretation, or there might be ambiguity, or different ways people want to understand a particular provision. So Article 12 on legal capacity was the subject of the first general comment, and we'll talk about some of that later. The committee can also issue decisions on individual cases if the country has ratified something called the optional protocol. An optional protocol is a small treaty attached to a larger treaty that in this case is an agreement to give the committee the power to hear complaints from individuals and issue a decision about whether their rights have been violated. So it's not a court, there's no enforcement power, it's not considered, it's not the same as a court, but it is characterized as decisions or as views alternatively. So view sounds a little bit less binding, decision sounds more binding. Technically, these are, it's kind of complicated, but it's not considered a court. It's not considered a court, it's not considered fully binding, but they often have a lot of influence. And they can also, if a country has ratified the optional protocol, make an inquiry into large-scale systemic violations in the country. So they've done that with respect to austerity in the UK, for example, how austerity measures were impacting people with disabilities, particularly. They did that on institutionalization in Hungary and a few others. The CRPD has been ratified by 185 UN member states out of 193. That's pretty close to universal ratification. As we know, the US is not among those countries. The optional protocol has been ratified by 104 countries, which is pretty good. It means in all of those countries, individuals can take complaints to the committee. The US signed the CRPD in 2009 under President Barack Obama, but has not ratified. And we can talk a little bit, I mean, there's all kinds of problems why the US does not tend to ratify human rights treaties. We have some very right-wing anti-human rights influences in that regard, and we need a supermajority of 2/3 of the senators to ratify a human rights treaty. So that's a high bar to pass, and we haven't managed to do it. The premise of the convention is that all people with disabilities have all rights on an equal basis with others. And I will explain a little bit more as to why that's really important for us as survivors of psychiatry, because our issues and our human rights tend to get segregated, sidelined, and undermined by being put under a mental health framing, by being treated as human rights in mental health. And what we were able to accomplish with the CRPD is to put ourselves totally as part of the equality-seeking group of people with disabilities, to say, we want full human rights, we demand full human rights and nothing less, equal as all other people, period. And what we're going to do in the convention is talk about the details of what that means in relation to particular rights. So I'll go into that a little more as I go on. The treaty explains what states parties need to do. So it's a non-discrimination treaty, and not just with our rights as people, survivors of psychiatry or people with psychosocial disabilities, however people experience themselves in the world, but for everybody. It was decided as part of the negotiations to that this was all, well, I mean, I think that was the premise to begin with, that it's all about non-discrimination. There was some countries during the negotiations who wanted to make sure that people with disabilities didn't get any new rights, or that this treaty was not going to be used to introduce new rights. So I remember at one point, this one particular delegate saying, no new rights, no new rights. And for us, that was actually wonderful, because no, we don't want anything new or different than anybody else. Exactly. We want these same rights everybody else has, no less. So that became a really useful thing for the disability movement. And the treaty explains what the countries need to do to ensure equality in the specific rights that the treaty actually goes into in detail. So I'm going to, if this is going to work out, I'm going to look at, if we can, the convention, just a little bit of the text of the convention, and I'll share the slides with you if you contact Jen later on. I don't know what's the best way to do it, or if you put it up on a website, so you could have all the links. I'm going to just go through a little bit now to not, so they have a preamble. Preambles are where they say some general value-based considerations, children with disabilities, women and girls with disabilities, gender perspective, conditions of poverty, peace and security. Interestingly, the individual having duties to others is under a responsibility to strive for promotion and observance of human rights, something on families, and there's a few other things. Importance of the individual autonomy and independence, including the freedom to make choices. So you can go look at that on your own. There's a purpose, which is, as I was saying before, about all human rights to all people with disabilities. Definitions of various issues, general principles. I'll highlight here respect for inherent dignity, individual autonomy, including the freedom to make one's own choices, and independence of persons. Also, respect for difference and acceptance of persons with disabilities as part of human diversity and humanity. We have general obligations. That's where there's obligations about changing legislation and policies and practices to conform to the convention. Guarantees of equality and non-discrimination, women with disabilities, children with disabilities, awareness raising, accessibility, right to life, which is not an anti-abortion article, but rather about the survival of people with disabilities, the right of people with disabilities to have access to what we need to survive, and to not be mistreated or harmed in ways that can kill us, which of course psychiatry can. Situations of risk and humanitarian emergencies, people with disabilities in situations of armed conflict, for example. Article 12, equal recognition before the law. That's where legal capacity comes in, and we'll go into that more later. Article 13, access to justice, which is equality and accommodations in legal proceedings primarily. Liberty and security of the person, that one's also important because we have this provision here that the existence of a disability shall in no case justify a deprivation of liberty. And that's how we have in international law a prohibition of involuntary commitment in the mental health system. We'll talk about that one more too. freedom from torture or other cruel, inhuman, or degrading treatment or punishment. We tried to get something into this article that would explicitly prohibit force, and the language that I had come up with was that it would prohibit forced interventions aimed at correcting, improving, or alleviating any actual or perceived impairment. That didn't come in, but a torture rapporteur later did adopt that standard and applied this to people with disabilities to say that forced psychiatric interventions could amount to torture. Freedom from violence and abuse, protecting the integrity of the person. Those are all in the same general topic area on freedom from torture, freedom from any kind of violence, protecting physical and, or it's really the right to respect for physical and mental integrity. Liberty of movement and nationality can be important in terms of potentially challenging discrimination against people with disabilities in immigration context, or maybe even visa context. Living independently and being included in the community, we'll also talk about that later on. Personal mobility, freedom of expression and opinion. I'm going through each piece of this because I know there's some of you who really are not going to be familiar, and I just want to make sure you're aware of the whole scope of what the convention covers. And I see in the chat I see some stuff in the chat, so I will check after I go through all of this and see if there's stuff that needs to be answered now. So respect for privacy, respect for home and the family. Importantly, there's the right to marry and found a family on the basis of free and full consent, the right to decide on the number and spacing of children, and to have reproductive and family planning education and the means to exercise these rights. Retain fertility, which is about prohibiting involuntary abortion or sterilization, which is also something that happens to our constituency. And ensuring that in no case shall a child be separated from parents on the basis of a disability of either the child or one or both of the parents. So this supports us in relation to discrimination in the child custody context, which is also a really huge issue, especially for women of our constituency. Education, health. Here, the important thing to know is free and informed consent is mentioned, and we'll discuss later how that works with legal capacity to give us, guarantee the right to refuse treatment. Habilitation and rehabilitation, work and employment. Another thing that can be very important for us, it doesn't get really specific enough about certain kinds of discrimination that our constituency faces, I think, but we can talk about that if people are interested. Adequate standard of living and social protection. This can be really important for housing rights, for for housing non-discrimination, for social security and social protection, that should be guaranteed as a right and not being made contingent on things like participating in compulsory psychiatric treatment, for example. Participation in political and public life, especially the right to vote. participation in cultural life, recreation, leisure, and sport. This is one provision I like a lot, and I'll just single out. And it was proposed actually by a friend and colleague of mine, Lex Grandia from the World Federation of the Deafblind. States parties shall take appropriate measures to enable persons with disabilities to have the opportunity to develop and utilize their creative, artistic, and intellectual potential, not only for their own benefit, but also for the enrichment of society. And I really like that because of how expansive and positive it is about a vision of what all people with disabilities have a right to aspire to. I am not aware of this provision actually having ever been used or talked about in concluding observations or general comments, but it's something to keep in mind. Statistics and data collection, international cooperation, national implementation and monitoring. And I'm not going to go into that one because I want to focus on the US context for this, and we're not even close to having that. But that's basically saying that you actually have to, if you ratify this treaty, have some kind of mechanism within the government to actually implement the convention, and also some kind of mechanism within the country that's designated as an independent mechanism to monitor the country's compliance with this convention, and that civil society, particularly people with disabilities and their organizations, shall be involved and participate fully in the monitoring process. And that actually, it's in this article on national implementation and monitoring, but it should, I mean, it is in effect really being applied to international monitoring as well. So most of the remainder of these provisions deal with the Committee on the Rights of Persons with Disabilities, saying that there should be such a committee created and that it should be made up of independent experts, high moral standing and recognized competence and experience in the field covered by the present convention, which is the human rights of people with disabilities. And they're invited to give due consideration to a provision that is all about participation of people with disabilities in any kind of process of any kind of decisions about implementing the convention. Also, that consideration should be given to equitable geographical distribution, representation of different forms of civilization and principal legal systems, balanced gender representation, and participation of experts with disabilities. As a matter of fact, the majority of members of the CRPD committee have always been people with disabilities. That's who ends up, that's just the way it has worked out, which is good. There have been 3 people with psychosocial disabilities as members of the committee. The first was Ada Maina from Kenya. The second was Gabor Gumbush from Hungary. The third was Diane Kingston from the UK. Currently, there is no person on the committee who's a survivor of psychiatry or person with psychosocial disabilities. And it would be great to, if any of us could keep, especially if we're from countries that are states parties, could really be thinking about if we ourselves or somebody we know would be good in that role, and see if they can get nominated from their country. So this is about the work of the committee, consideration of countries' reports, cooperation, that countries are obligated to cooperate with the committee, relationship with other bodies, and that's the sort of legal hook which says that they can consult with NGOs, which they do frequently and extensively, especially when your country is under review. The committee really relies on what you can bring to them, what you can tell them about the situation in the country, and what kind of questions you might recommend that they ask your country's delegation when they come, and what kind of recommendations you think that they should make to your country. So that is really important to know. I think probably most of you from countries that are states parties know this very well, and you're already participating in that process. It's important for everybody to be aware. Oh, and I will also say that it's important to know there's no requirement that when NGOs or even individuals send information to the committee, that's something called shadow reports or parallel reports to the committee. You can do it even as an individual. You can do it as an informally organized group. You can do it as any kind of group. You do not have to join a national coalition. There is no such thing as an official shadow report. Sometimes governments will even say that they're assigning some organization to write the official shadow report. And that's entirely contrary to what the NGO's shadow reports are supposed to be about. So don't be intimidated if anybody is trying to tell you you have to join up with the national coalition, or that there can only be one shadow report, or there's no requirements, and you can do it even as a single individual. So Conference of States Parties meets annually. This is something that's new in the CRPD for Human Rights Treaty. Well, all human rights treaties, all UN core human rights treaties have a Conference of States Parties at least every 2 years to nominate and elect the people who are going to be the committee of, who are going to be on the committee of experts. It rotates. The CRPD is unique in human rights treaties for this part that says that they meet regularly to consider any matter with regard to implementation of the convention. This was something that was brought into the convention from representatives of the Landmine Survivors Network, which had been involved in negotiations of the landmine treaty. And it's really, so we really actually benefit a lot from having this provision, because it means every year in New York, people who are able to get themselves to New York, governments and NGOs can come and participate in a bunch of events. And there's now some online events as a result of the pandemic, and that's continuing. So the remainder of these provisions are pretty formal stuff about signature and ratification and entry into force and reservations and all that sort of thing. And that's the end of this. I won't go into the optional protocol, and I hope it was useful for me to go through the provisions of the treaty. I'm going to check out the chat now to see if I can. I might have to stop the share to do that because I can't find it. So I'm going to stop the share and see if there's any questions that oh, I see that a lot of this is that people sharing their email to be in touch. That's
This
great.
is
Okay,
Laura Rose. I did have one question.
sure.
May I ask it?
Okay, let me just ask, should I stop the recording now, or is it okay to just go on with the recording?
It's okay, thank you.
Okay, go ahead.
So I had a general question. You mentioned something about like how there's some provisions around immigration or the ability to move as a right. And I'm just curious, like I've heard that, and I don't have anything to validate this, but as I understand, I heard there's a restriction about people moving into New Zealand if they have a certain BMI body mass. Is that the kind of thing that this might address? And then of course, that would be dependent if New Zealand was one of the countries that signed on.
Yeah, New Zealand is a state party to the CRPD. I think, I mean, you know, I mentioned that, but that is not actually something that, it's not actually something that I really know a lot about, of how you could end up applying those provisions in relation to immigration. Usually, you're seeking to apply the convention exclusively by one country, right? Like if you're in the US and if the US had ratified the treaty and the US is maintaining forced psychiatry, the US is violating our rights. Or the US, if the US, you know, locks somebody up in a psychiatric institution, the US is violating that person's rights under the treaty if the US ratified the treaty. But with immigration, it would be somebody, I guess, who would want to immigrate to that country and would say, and there may not be any particular reason why you can't do that. I think if BMI is something that's considered a disability, and it would make sense that it is, then I see no reason why you couldn't argue that. So,
Thank you.
yeah, I'm just trying to see if I can just go back to that. It's not the this before it. Yeah, I mean, I just don't know enough about those provisions to really say anything more about it. But yeah, are there any other questions at
I have
this?
a question.
Go ahead. And can I keep recording or should I stop? Should I pause the recording?
You can keep recording if you want.
Okay. Go ahead.
My question is if the optional protocol isn't ratified by a country, what kind of teeth does this law actually have for that particular country?
Well, a lot depends on how the country's constitution and other laws treat the convention in terms of its national law. So I know about Mexico, and Cecilia would probably be able to give us a lot of detail about that. But in Mexico, the CRPD is really brought fully into the national law. And I know there have been many cases that go up to Mexico's Supreme Court where you can get rulings that are based on the convention, that are applying the convention and enforcing the convention. And then it's a question of how the court is interpreting the convention. And so the disability movement is always trying to make sure they're interpreting it correctly, that they're not, that they should be applying not only the literal text, but also how the CRPD committee is developing an analysis and interpretation of the text. And then, as I know is also an issue, it's a question of different levels of what the federal state in Mexico and the states that sometimes will have their own laws, and how easy or possible it is to actually enforce that. So Cecilia, I don't know if you want to say anything briefly about how things work in Mexico, or just leave it at that. You can unmute and let me know if it's okay to keep recording while you speak.
It's okay to me. It's okay to me, the recording
Okay.
to my intervention. In Mexico, with our legal system, to demand that in Mexico, the Supreme Court has the right and the voy a decirlo en español, Tina, perdón.
Sí.
Because the cross of the legal concept is very hard to
I
me.
know. I understand. Yeah.
Sí, es que quiero decir mandatorio, pero es obligatorio. En México es facultad. A ver.
You know what? I'd love to offer to translate your Spanish, but I don't think I'm going to be able to right now. It's just like.
No, don't worry.
Yeah.
Let me say in Spanish, and maybe it's more easy to translate to English. Well, sounds of the city. En México, la Suprema Corte puede implementar una interpretación definiendo si una ley es compatible con nuestros compromisos con la Convención. Y dos, señalar obligaciones específicas para que las autoridades, por ejemplo, legislativas, cumplan con la Convención, incluso si no hay ley en México todavía. Es el caso del artículo 4.3.
Okay, so in Mexico, the Supreme Court can say if a particular law complies with the convention or not, and can say what the authorities have to do in order for it to comply with the convention, including if there doesn't yet exist the necessary law in Mexico.
Sí, en México podemos reclamar que la ley no se parece, doesn't match, no está armonizada con la convención, o que el acto específico se abstiene o omite cumplir la ley. Por ejemplo, con la accesibilidad. Si un edificio no es accesible, podemos ir al tribunal y reclamar que gasten presupuesto y lo adapten, pero es desgastante ir al tribunal.
Okay, so I'm just trying, I'm struggling because I also want to go on to some other stuff, but I'll just say that you were saying that, for example, with accessibility, I don't know, I'm sorry, it's like I was just having trouble keeping it in my mind.
Maybe the perfect word is what about in Mexico, we can record to the court if in two cases. In a case of an act, an omission.
Okay. Got it.
Sí,
Yeah.
O hacer o no hacer. Las dos cosas las podemos reclamar.
Okay, so I think that's a good sort of example for people to know about as to how it can work in one country. And each country is going to have their own ways of dealing with the convention in terms of their international law. So in the United States, when we ratify a human rights treaty, there's always a lot of understandings and declarations and reservations attached. And among them are some that essentially say there's no private right of action, meaning individuals can't take it to court, and that it's non-self-executing, meaning that they consider that the convention does not actually become part of our domestic law unless there's an actual statute passed at the federal or state level that implements the convention. So you could say, let's say on the issue of forced psychiatry, you could say, if we ratified the CRPD in the US, and if we could get the Congress to pass a law saying all the US states have to abolish their involuntary commitment and involuntary treatment laws, that would be what would be enforced, and not the CRPD directly. So, or if the Congress would pass a law in saying, just enacting the text of the CRPD and saying all US states are bound to implement this in their domestic, in their state law. So I want to go on to some of the issues related specifically to the abolition of forced psychiatry and other issues related to that. I'm going to skip a lot of what I had. I have some things about the process of creating the convention and what came before it. I think this is interesting historically, and you can see it in the slides when you get the copy of the slides. What's important is the provisions in the convention that I've been singling out that are helpful to us in abolishing forced psychiatry. They didn't get there accidentally. They didn't come down from the sky. They weren't top down. They didn't come because the UN suddenly decided they were going to do something different than they had been doing all along. They came because some of us were there. I was there representing the World Network of Users and Survivors of Psychiatry. I was the lead representative and did quite a large part of the work in that regard, and drafted proposals for text of the treaty and that sort of thing, always in consultation with others and with the board of the World Network and the membership, et cetera, et cetera. So it's just important to know that this treaty in a lot of ways comes from us, comes from our constituency together with other constituencies of people with disabilities. And I say this to give survivors and people with psychosocial disabilities a sense of ownership of the treaty. And so the aims were to get our core issues into the convention, prevent any limitation of our rights from coming into the convention, and ensure that the whole treaty is relevant to us. So to ensure that there's nothing in any part of the text that just, seems like it could be used against us, or that it doesn't really apply to our particular reality. There's some things that, are, for instance, about deaf people and blind people, or it may not be that it's that much of an issue for most of us, but that's not what I mean. What I mean is, say, that anything that's generally applicable is being dealt with in a way that we can live with and use for our human rights in case a particular right does become at issue for us. And this is what we said are our core issues. we define our human rights. Involuntary commitment is discriminatory, disability-based detention. This was a simple logic. So this was a very simple application of non-discrimination, because involuntary psychiatric commitment is always based on a psychiatric diagnosis. If it's not based on a psychiatric diagnosis, then the international community is up in arms saying, oh, why are you locking up this sane person? So in a sense, what we have here, what we have with this provision, or with this premise that did come into Article 14, is a gotcha. Because if it's not based on psychiatric diagnosis, they already think it's not acceptable to lock someone up in a psychiatric institution. And now human rights law is telling them, you can't lock anybody up in a psychiatric institution because you're singling out people based on an actual or perceived disability. And the real issue behind that, it's not just a silly gotcha. It's saying that there's no reason that a disability of any kind, and in particular, experiences of altered states of consciousness or distress or anything that psychiatry likes to diagnose, there's absolutely no reason for that to be treated as a reason to take away someone's freedom. So there's different, we have answers to all the different objections that ever get raised to that. If anybody wants to hear what those answers are, if that's something would be useful, we can discuss that. All of the danger to self or other stuff, danger to self ends up, if you take away someone's freedom because you think they're going to be dangerous to themselves, that violates the right to legal capacity, because people have a right to take risks. And if you lock someone up because you think they're going to be dangerous to other people, it's a discriminatory kind of preventive detention. People who psychiatry labels have a right to be free under the same conditions as everybody else, and to be subject to any general laws that a state might legitimately put into place to prevent people from committing violence against others. So another core human rights issue we put forward is that forced interventions in the name of treatment constitute torture. It's state-condoned violence. I know for myself that the aspect of forced drugging, that was the fact that this is the state legitimizing it, meant that I had absolutely no recourse. You can't call 911, you can't call the police and say, hey, they're drugging me, because the laws allow them to actually do that. And in 1986, the Special Rapporteur on Torture of the UN at that time had already acknowledged then that the administration of neuroleptic drugs was a form of physical torture. Like, let that sink in, because you had organizations like Amnesty International and Human Rights Watch in the 80s and 90s, and generally up till the time of the CRPD, they would be very ready to take up cases of people who were locked up in psychiatry for reasons that seemed very clearly to be retaliation for their political advocacy. But they could pass by the 1,000 other people locked up in an institution who didn't have that kind of backing, who they just would say, oh, those people are just mentally ill, it's okay for this stuff to be done to them. That always really gets to me. And the way that that administration of neuroleptic drugs was characterized in that report in 1986 was that they cause trembling, shivering, and contractions, but mainly make the subject apathetic and dull his intelligence. So setting aside the male bias language, which was, par for the course at that time, those are the signature effects of neuroleptic drugs that Peter Breggin and others, have called attention to: akathisia and psychic apathy and indifference. So that's what we were advocating. And as I was mentioning, in 2008, the Special Rapporteur on Torture actually did take on our advocacy that forced psychiatry can amount to torture or other ill treatment. And the strongest statement we have from a UN Special Rapporteur on Torture after the CRPD came in 2021, when the rapporteur holding the position at that time said that psychiatric interventions may well amount to torture, and puts forced psychiatry in the class with political or religious re-education or conversion therapy related to sexual orientation and gender identity. So characterizing it as the same type of discrimination that goes deep to an individual's personality. Okay, so equality and discrimination and non-discrimination in all civil, political, economic, social, and cultural rights, including equal legal status. That was how we were just touching on legal capacity in that beginning stage. And finally, we put an end to discrimination at the community level and in the media. Okay. So legal capacity emerged as a very central paradigm shift in the convention. A lot of people talked about this term paradigm shift in relation to legal capacity. I'm not really sure who was the one who started using that term. and I'll, there's a whole history with that as it evolved through the negotiations. But legal capacity really captured the imagination of government delegates as well as civil society, I think for many reasons, because it wasn't only one group of people. We are still, and we're still in the negotiations, a marginalized group among people with disabilities. It turned out that people with intellectual disabilities, of course, are also very much affected by deprivation of their legal capacity. And the organization representing people with intellectual disabilities and their families also was agreeing that we should not be doing guardianship or substitute decision-making. They had come up with the idea to have supported decision-making, to have a right to have support in exercising legal capacity. At first, that organization was really seeing, they were seeing it as, we need recognition of supported decision-making as a way to exercise legal capacity as an alternative to guardianship. For the World Network of Users and Survivors of Psychiatry, we ended up taking a very strong position that you cannot have guardianship or substitute decision-making under any circumstances, because we felt that to have any kind of guardianship or substitute decision-making available is just, then none of us are safe. There's no way that you can kind of say, well, some people, it's okay to not respect their will, to have someone else put in to make all the decisions for them or to make any decisions for them, but everybody else should be fine. If you give the state the power to make such a decision about people, there's no telling when or how they're going to apply it. The same as there's no telling, you can't have it a gray area in relation to forced psychiatry also. Jen, you have a question, and is it okay to keep recording? Great, okay, go ahead, please. Unmute.
Just wanted to let you know, Julia Alexander had posed a question in the chat, and I'll read it to you. It says, would involuntary commitment be based on mental status and practice? A person might have a psychiatric diagnosis, but stable except in a period of exacerbation when a practitioner has reason to think there's imminent risk, or, for example, people who intend to kill themselves, declines safety planning or other modifications of risk.
Thank you for the question. And there's two ways to answer that. One, the main one, based on the text of Article 14, is that, or the whole premise of that you cannot deprive someone of liberty based on a disability. The disability is always the threshold criterion. If they aren't applying a psychiatric diagnosis, there's no way that you can have psychiatric involuntary commitment applied to you. So it's a threshold criterion. And I'll discuss that in a minute in relation to Article 14 and how that came in, but the CRPD committee has explicitly interpreted that based on the negotiating history, and particularly that this issue of whether you can have other factors in addition to the psychiatric diagnosis that could somehow legitimize it, like danger to self or others, or grave disability or deterioration, need for care and treatment, whatever. Some countries were proposing to add solely or exclusively. So the text would have read, shall in no case be based, deprivation of liberty shall in no case be based solely on a disability. If that had come into the text, then absolutely what you're saying would have made it legitimate. But that was rejected. It didn't come in, and there was at least one country, actually the country that I know was taking this stance was Mexico, that explicitly did not, that explicitly rejected solely or exclusively. So Mexico took a stand the same as civil society, saying no, that you cannot allow additional factors added on to a disability to actually legitimize a deprivation of liberty. And so the CRPD committee interprets it that you simply cannot have it in any circumstance. You cannot have it based on additional factors. I see Pat has her hand raised, or his hand raised.
Hi, yes. I have been subjected to forced psychiatry several times, and it's because I'm not able to process serotonin drugs, and will go into psychosis. And I was locked up as a teenager and into my early 20s and told that I had a psychosis diagnosis. And I'm wondering, with the latest research coming out, I believe it was Moncrief and Mark Horowitz that says that there is no chemical imbalance. I was wondering, is any of that research getting into the dialogue against forced psychiatry? Because they lock people up and they make us sick. They disable us. So it's, yeah, I was wondering, is any of that, research making it in there so that we can end this? Because, people who follow Robert Whitaker know his writings that the psychiatrist treatment itself is what is disabling so many people.
Yeah, thank you for that question. And I didn't ask you if it was okay to keep the recording on, so I hope that was okay with you.
Yes, it's okay. Thank you. I turned off my video, so it's okay.
Okay. There's a lot of pieces in there, because one piece is that harm as an argument to abolish forced treatment and involuntary commitment. Another piece is the fact that that harm actually was then used as a basis for them to psychiatrize you again, or to do involuntary psychiatry. And maybe the first what you were using, the serotonin drugs, was consensual. We have now been promoting reparations for psychiatric violence. That's what I would really most go to in talking about the issue of harm. The CRPD committee last year issued a set of guidelines on deinstitutionalization, which is very comprehensive. I discussed that in an earlier webinar for Peer Galaxy, and I think we have that available on YouTube. It may be on the CRUSP YouTube channel. And just to say that the guidelines contain a total prohibition of any deprivation of liberty in any mental health setting for any duration. It's considered a form of institutionalization. And people who have been victimized by disability-based institutionalization are entitled to reparations. And there's a whole very developed section in the guidelines on reparations. I don't want to go into that a lot now because we did discuss it in the previous webinar. I think it's very helpful to have it in there. It's helpful for people in countries where they have the obligation to implement the convention. It's even helpful for us in the US because it's a recognition that it's a real recognition by a body of the United Nations that what's been done to us in psychiatric institutions and in any kind of institutions is a serious, complex human rights violation that we're entitled individually and collectively to have repaired, to get some justice for. So we've gone into a lot of different stuff. I want to just, for people who may not be aware of some of the details, I want to mention what are the pieces of these core provisions in the convention. So Article 12 on legal capacity, the main points are everybody has legal capacity, people with disabilities. Maybe I'll just go to that in the thing. Article 12, yeah. So states parties recognize that persons with disabilities enjoy legal capacity on an equal basis with others in all aspects of life. The all aspects of life there is one of the ways that we also apply legal capacity to say you cannot deprive someone of the right to refuse psychiatric treatment on the basis that they lack the capacity to make a decision about treatment. So I know in the United States, we have some case law in New York and in Massachusetts, particularly, probably in other states, case law or statutes saying that people can be drugged against their will if they lack the capacity to make a treatment decision and the court considers that it's in their best interest to have this drug administered to them. So under the CRPD, legal capacity in all aspects of life, combined with the provision requiring free and informed consent in healthcare that we saw in Article 25, that means that everybody has to be respected in making their decisions about psychiatric treatment or about any other kind of treatment. And we have this, I don't know how I can change what I'm sharing. I'll stop that and go to another one. We have I don't know where I put so many different things in these slides, and and that didn't even work. There's the Committee on the Rights of Persons with Disabilities put out what is sharing now? What's on the screen? Are you seeing the Article 12?
It says victories and milestones.
Oh, okay, so you're seeing, I don't know how to get back to my slide. Sorry, I'll have to go back there. Okay. Okay. I'll just say, because we're discussing legal capacity, the committee's first general comment was on legal capacity. And they had a lot of good stuff put in there that's relevant to abolishing forced psychiatry. One, the concept of mental capacity cannot be used to restrict a person's legal capacity or decision-making, that people have legal capacity at all times, including in crisis situations, that the right to exercise legal capacity cannot be conditioned on acceptance of support for exercising legal capacity, that there's a right to refuse support. So if someone wants to say, well, you can only make a decision about treatment, or you can only, not have a guardian if you accept somebody to support you in your decision-making, that's not the case under the convention. You have a right to refuse support. And the committee said that in general comment number 1. Forced mental health treatment violates the right to legal capacity, and it also infringes and violates the right to be free from torture or other ill treatment. So actually it was in the guidelines on Article 14 that they fully came out and said that it also violates the right to be free from torture or other ill treatment. They addressed it in a somewhat weaker way in the general comment, but that it violates legal capacity and freedom from torture or other ill treatment. And this wasn't in, I think it's important to recognize that as being part of the general comment. And they also said in the general comment that there's a right to have non-medical options. So that was something I had actually not even paid much attention to until a colleague Bea Perez pointed that out to me, that whole aspect of right to have non-medical options is developed in much more detail in the guidelines on deinstitutionalization. So I'll refer you back to our other previous webinar for that. And then the other piece that's important in the general comment is we were struggling with situations that are super extreme, like coma, in the negotiations. So we wanted to make sure that the right to legal capacity would apply fully all the time, that there would not be for anybody in any situation a possibility of having their legal capacity questioned. So the committee finally resolved on saying that a best interpretation of the person's will and preferences would be made when, despite considerable effort, it is not practicable to determine the person's will and preferences, and that for adults, you cannot use a best interest standard. Best interest applies to children. It is really substitute decision-making. It's what I think is good for you. Best interpretation of will and preferences means I'm really not getting a determination of your will. Like the paradigmatic state is that you're in a coma, and I'm not able to communicate with you. There's just no communication happening. And so I'm going to ask people who know you well, if you have an advance directive, that should really be dispositive, that, you know, I should absolutely be following your advance directive. And what we've done in some of the implementation, and I think Mexico's national legal reform on legal capacity actually goes pretty far to do what I'm going to say, that there needs to be an obligation that if somebody wants to make a best interpretation of will and preferences, they don't just say, I don't know what you're saying, so therefore I'm going to just make an interpretation and go away, act on my interpretation, and you know, you're done. That's going to be obviously abuse. That's going to be substitute decision making. So you have to actually keep trying to engage with the person. You know, you should say, this is what I think is your interpretation. Is the best interpretation of your will and preferences. Is that correct? And if the person is reacting in a negative way, then your interpretation is wrong. It's therefore not the best interpretation, and you have to go back and try again. And also because people might, if you're in a coma, you might come out of the coma. So Mexico does require that you keep going back to the person. You don't just take like this, like it's a one-time only thing to do a best interpretation. So Jen, I see you are raising your hand, and please go ahead.
Thank you. You know, I find it interesting about the whole legal capacity question, I guess. You know, recently, and I've been talking to you about the 988 progress in the U.S. with the 988 suicide prevention alternative to 911. And since its inception, only 11 months now, there's been a 200% increase in civil involuntary commitment. And in the state of Georgia alone, where I live, since 988 has been in effect, there's been over 4,000 civil involuntary commitments. Those are 1013s in Georgia. And so I'm curious as to how we are going to be able to provide reparations to these people. 80% of these people that are being 1013 are people of color, are BIPOC people, basically African-American men and women. And I think it's less than 15 that are Caucasian. So I'm curious to know what we can do in Georgia when we get to the subject of reparation for the states, and what we can do to correct this.
So, you know, the US hasn't ratified the CRPD. And one of the things that I've actually been thinking a little bit about is that I haven't really gotten far in thinking about it, is that even for countries that have already ratified the CRPD, there's a lot of us whose rights have been violated long before the CRPD came into force. You know, my rights were violated by the state and by the psychiatric system in 1977, and that's a long time ago, way before the CRPD was even thought of. So how to deal with that aspect of reparations in terms of the
You froze.
you know, like one possibility would be to argue that because this has always been, you know, for instance, that it's always been discrimination, that there's always been, say, at least since 1986, it was being recognized that forced neuroleptics are torture. So there could be arguments in that regard, and especially about discrimination. But, you know, if that's not, you know, I think what would end up happening is that for purposes of systemic collective reparations, for purposes of guarantees of non-repetition, for purposes of systemic changes, apologies by the state, apologies by the psychiatric system, if we want that. I frankly don't. Or at least, like, for me, reparations, like an apology from the psychiatric system, I would only accept if they have stopped promoting forced psychiatry, if they have actually done their part to abolish it. Meaning, if you're a state hospital administrator, no forced treatments in my institution, period. No involuntary commitments in my institution. You know, civil disobedience, you know, if there's any laws that require them to do it, because it's a serious human rights violation amounting to torture and arbitrary detention. But the one thing I think so like there's these legal issues in terms of what the legal reparations obligations would be, and how to address that in advocacy, creating reparations mechanisms, how we're going to conceptualize that and work with it. But I think one thing I would want to say is that at least for descendants of slavery in the US, obviously there's a huge movement for reparations, and also for indigenous peoples, I think. I mean, those are two groups that I think have very strong collective reparations claims for indigenous people for sovereignty violations, and also and African Americans for race-based discrimination. And I mean, and for enslavement in particular, but as a group that has been defined by a racialized identity. And I think you would need to, you know, it would be a good idea, it would be interesting to bring in the issue of reparations for forced psychiatry into those discussions, you know, obviously by people who are part of that community. And, you know, if they want to you know, to ask anyone else to give advice or whatever, solidarity about it. So yeah, that's what I would say. And I see Joy has a hand raised. Go ahead and let me know, is it okay to keep recording?
Yes, please. It's okay.
Okay, go ahead, please.
All right. From over here is good evening. So, good evening, everyone. I have a question to ask, and so it's about still on the CRPD. So now over here in Nigeria, the CRPD was ratified in 2009, and the optional protocol in 2010. And up till this time, so let's say 10 years plus down the line, we're still struggling with implementation of these provisions in the CRPD. So my question exactly is the CRPD binding? Does it have any binding effects on a country that actually ratifies it? What are the implications if these countries, after ratifying it, do not implement it? What is the outcome? Like, what holds them accountable?
Yeah, thank you for that question. So there's the way that these human rights treaties work, and I'll just explain a little bit about what it means to call them international law, because traditionally international law was law between different countries. So like the classic kind of thing would be a dispute about rights in the ocean, say fishing rights between two countries that both have, you know, both have their boundaries in an area, and there's an on a coastline, and that there's an area of ocean where both of them have been claiming exclusive rights, and there's a dispute about it. And for that kind of international law, other countries, I mean, well, for that kind of international law, there exists an international court that decides the claims that different countries can make against each other. It's called the International Court of Justice. If there's an international law that's a treaty, like a peace treaty, that's binding among many countries, you might have other, like let's say one country violates a peace treaty, then you might have other countries, all the other countries having an interest, and they could do something in retaliation. Human rights treaties are multilateral treaties. They're treaties among large numbers of countries. As you see, you know, it's CRPD has nearly universal ratification among UN member states, and the other human rights treaties mostly also have near universal ratification. But we don't have a court to monitor the CRPD. What we have amounts to different advocacy possibilities to put pressure on a country to actually do the implementation. So the main pressure is applied through the periodic reviews of different countries and the issuance, adoption of concluding observations. So I don't know where Nigeria is in the schedule of the reporting right now. You know, they have 183 states parties, and they meet twice a year, the CRPD committee, and they review maybe, I don't know, 5 countries in a session. So that means that they don't get to each country. They may not get to each country for a while. And when your country does come up for review, it's important to do your advocacy in the strongest way possible. It's also important to do advocacy at the national level, which I know that you are doing in Nigeria. You have to be doing your advocacy at the national level, you know, whether it's trying to persuade legislators to enact the kind of legislation that needs to be enacted, to repeal legislation that's discriminatory, advocating for the government to adopt policies that you favor, that are needed. And that's a good basis then. So then you go, it's a good to do that in interaction with some strong advocacy to the CRPD committee. So you put in a shadow report and you say exactly what you think, you know, exactly all the ways that your country is violating the convention and what needs to be done to comply. Don't hold back. The CRPD committee is very, very friendly, you know, I'll say to the kinds of claims that I've been discussing here, to advocacy that the, you know, mental health laws that allow involuntary commitment have to be abolished, period, not just reformed or modified, but any legislative provisions allowing this kind of thing have to be entirely repealed. You can give them the details about, you know, say, you know, I'll say if it was the US, I would, if it for New York State, I would say New York State has to repeal Mental Hygiene Law, Article 9, which is called the Mental Health Act. And it's all about involuntary commitment and involuntary treatment. And I'd say you have to instead enact a very simple law saying everybody is now to have the right to give or refuse free and informed consent for any aspect of mental health treatment, diagnosis, or hospitalization, and everybody is to be considered to have the legal capacity to, you know, to make that decision. And for that legal capacity piece, I'll thank Mexico for having put it into their health law. I know it's not perfect, and you have all kinds of needs for further implementation, for actual implementation there. So that's the kind of thing that you can do. If since Nigeria has also ratified the optional protocol, with the optional protocol, what you can do is, if you are able to take a case through the national courts or pursue whatever kind of domestic remedies are available for the particular violation that someone wants to challenge. Once you have done all that, it's called exhausting domestic remedies. You can take that as a complaint, or I think they call it a complaint communication to the CRPD committee. And it can take, you know, it can take a few years, but they will eventually issue a decision. So that could be someone or a group of people who are involuntarily committed somewhere. You can also, and this applies to people in countries that haven't ratified the CRPD, or if you haven't been able to exhaust your domestic remedies, maybe you just don't have access to lawyers. People can't afford lawyers often. And it just costs too much to do that. You can take also communications to UN special rapporteurs. So for instance, the special rapporteur on the rights of persons with disabilities, the special rapporteur on torture, the special rapporteur on health are the ones that have at times addressed these issues. And you really have to check, research, who is the person who is in that role currently. And if that's the person you want, you know, contacting your country and trying to put some pressure on them to, say, release the person. There's also the working group on arbitrary detention, which came out with some good standards opposing forced psychiatry, and that could be that can also be another avenue. And the working group on arbitrary detention issues decisions in a form that's similar to what the CRPD committee issues under the optional protocol. So those are the kinds of things that you have available. And it's all essentially tools for pressure. It's tools to use in your further advocacy. And it's not a court decision. So I hope that's useful to you and to everyone really in thinking about, you know, there's a slogan, I think, in Asia, in UN SCAP, make the rights real. So how do we make the rights real? Cecilia? Go ahead.
Yes, thank you, Tina. It's about the best interpretation of the preference of the people. One thing, when at the time in the court do this criterion, the resolution doesn't have any analysis or pronunciation about the safeguards. The case is about a man that do a donation to his non-wife partner, his concubine, and the court says, no, the donation is okay, but never say anything about the lack of safeguards. That's a problem. Have in our law about the mental health has a different problem, but in this case, the possibility of abuse worries make a different arrangement. Without interdiction, the family members have the full right to have an opinion about the treatment of the person. In this way, they doesn't have a bidding about this kind of better interpretation, because remain the substitution of the voluntary of the person, of direct person, is in the law and is more bidding than the criterion of the court, and is later in the law, is recently, to the last year.
Yeah, I mean, I'm not sure if I'm fully understanding what you're saying, but I think you're saying that since the court didn't address, in the court's pronouncements on legal capacity, they had not addressed the issue of safeguards or best interpretation. And so then you had family members still doing substitute decision-making. And now the law actually has addressed that, the national law. So yeah, thank you. And that's a recent development that was just enacted this year. Thank you.
Estos avances en la corte generan una cuestión muy reactiva y cancelan el avance del criterio de la corte.
Okay, she's saying that I don't fully understand what's happening, and I don't want to get into that much detail now. She's saying that what the court did cancels the advance, and I don't fully understand that. I think I'd love to talk to you more about that at another time. I think what that shows is this is a long fight for our rights, that even in countries where you have laws that look good, that have a lot of good elements in them, there's still a lot of work that needs to be done to make sure courts are interpreting them properly, to make sure that that there's nothing else coming up that could end up being used to abuse people's rights, to somehow get around what the law says and keep doing substitute decision-making. So I want to just see what, let me just take a look at the time. We just have really 15 minutes left. So there's so much to talk about, and I'm not, let me just see what could be useful. You can always look at my slides, and some of them are probably going to be too cryptic to be, oops, what did I do? To be really useful, but yeah, I don't know. Like, I guess I'll just ask if there's anything at this point that people want me to talk more about, because maybe I'll just stop the share. I can always start again if there's questions and I have slides on something, but if you would like to ask any kind of questions about anything that I've talked about, or if there's anything particular that you'd like to know about, and I can go to, please go ahead. And I see a question in the chat from Sarah that I'm going to read out. If neuroleptics impair the intellect, how can people ever even actually regain legal capacity when they're drugged? Is it just a nominal capacity? It's hard to make decisions in that state. So the standard under the CRPD is that you can't deny a person the legal capacity to make decisions. Having said that, I think, you know, so part of what that means is nobody should be in a state of being heavily drugged, because there shouldn't be any compulsion or coercion to take drugs. And there also should be the societal changes, or the changes in our environments and communities and the kinds of supports available, the non-discrimination at a very basic community level that should be put into place through awareness raising and all kinds of things. That would mean people should not have to choose to be heavily drugged in order to live in society and not feel that they're going to risk violence and discrimination and abuse from other people. I think, you know, if you're being, I think that the question of how to deal with the effect of drugs, I mean, you still have, your legal capacity belongs to you. The only way to not say that a person has legal capacity is to kind of say, I can't recognize you as a person making decisions. And then the implication would seem to be, well, somebody else is going to be recognized to make decisions for you. That's the way it has worked with guardianship or substitute decision-making, or a court deciding on forced treatment. And so maybe the answer in that situation is to treat a person sensitively in their decision-making, to not take advantage of the vulnerability that they're under because they're being drugged. And maybe we need more general safeguards of the kind that are about not taking advantage of people, And there is in the CRPD, in the text of Article 12 and in general comment number 1, that there should be safeguards against any kind of undue influence. So that's what I could offer as a suggestion there, but there's a lot of what we need to do that is not necessarily going to be done through legislation and enforcement of legislation. And some of what you're talking about is in that area. Jen? Go ahead, please.
Oh, hey, Tina. I was also wondering, with the next presidential elections coming up in the US fairly quickly, what kind of strategies can we do with the Dems to see about ratifying the CRPD here in the US?
I don't know. I mean, with Obama, you know, the president at this point doesn't have any role, you know, right? Like with Obama's campaign, I know the disability community had done a lot of work connecting with his campaign, pushing him to make a commitment to ratify this, to sign the CRPD if he got elected, and he did. If there are campaigns for the Senate, the disability community in states where there's a campaign for the Senate and there's senators who have not, you know, there's, whether if there's, you know, people could make campaigns, people could make that an issue in Senate campaigns to get senators to commit to not just voting for ratification, but pushing for ratification if they get elected. And because since there's a lot of reservations, understandings, and declarations that have been attached to the CRPD in the form that it currently sits with the Senate, I don't think it has to go through again. I think it would just be if they want to take it up where it left off. There would be a question whether we want to push for the removal of those reservations, understandings, and declarations. That's the position that I had been taking when I was actively advocating on this, when it was actively in play. You know, I don't know, you'd need a huge effort from the whole disability community, and you know, I don't see it happening right now. It just doesn't seem as if it doesn't seem as if people have a sense of enough possibility of change in this area and in some others for it to be an electoral issue. But if it is, that's what they would do.
Thank you.
Do we have any more questions? Kevin, go ahead, please. And are you okay with it being recorded?
Yeah.
Okay, thanks.
Well, just want to say I appreciate your work over all these decades. I've been a big fan of your work and your earnestness and persistence. So thanks for that. Here, I had a nightmare last night, and what it was is that we, and helping professions, recognized that a whole lot of people that had been traumatized either in family relationships or individual relationships or by the system. And we went back to the system to ask them for ways to help people heal. And all they said was, all we have is a collection of brain pills to mute your suffering from us. Are you game with that? Now, that's very crude, and maybe there's a simpler way to say it, but my heart hurts because I think in my mind, that's my estimation of 98% of our public mental health services. And I talk to my friend Laura Rose about this all the time. We have under the, you know, if you looked at a tier of 7, you know, Dante's hell, the first is supports and services that meet your needs, and we'll stick with you on our helpline to make sure you get the services and supports that you choose. And then underneath it, the subtext of we're going to get those people the help, the treatment that they need. And then underneath treatment in Oregon is we got to get brain pills to you as fast as possible. So when we say treatment, we're actually aggressive prescription of psychopharmacological chemicals. Now, I'm not debating people choose those, and those have some benefits for some people. Certainly they do when be using them. However, this is like Stalin's bread shop. There's nothing else in it to heal or even to recognize what you've been through, except to take a handful of pills to create emotional numbing so your problems don't bother me and you're not bothered by them. But unfortunately, we live with people who are disassociated and removed from their own experience. Where do we, and it seems like the tide is turning with Newsom's custodial care, calls for different things like Kendra's Law, redo in New York, on and on. Where do we go here? Because I feel demoralized, that I'm pretty, like Todd says, be careful, Kevin, to not prettify the plantation. This stuff is onerous. All this involuntary stuff breaks people. Well, just love to hear you riff on some of this stuff. Thank you.
Well, what I think we most need in the US is for every community of people, whatever you consider your community, whether it's geographical or, like what someone once called thematic, like if you are lesbian or gay, if you are a person who hears voices, if you are someone who lives in a particular neighborhood and you're connected with your neighbors, whoever you feel like this is my community, see if you can find ways to organize mutual support with them. See if you can find ways to organize crisis support, helpline, warm line, whatever kind of support that you feel that your community feels is needed. And we have, like Jen mentioned, the 988 system that's so problematic because they will call the authorities on people. They will, send the police to your door, send the mobile crisis to your door if you don't want them, if they think, whatever, danger to self or others. So for many of us, that's simply not safe, right? And there are some alternative helplines that make a commitment that they will not ever call 911 on you. There's one that I know of that is, generally available from the peer support community. That's the one from Western Mass. I forget their name right now. There's a trans helpline, there's a Black helpline, and there might be something else that I'm forgetting. I think, that has given me the idea that I think it's important for people to do as much of that as possible. You probably also know there's some community kinds of community organized crisis support. Some of them are pretty medical models. Some of them work with the police that I wouldn't support. There's one that I've heard about in Denver. I think it's called STAR, that when I heard about that, it seemed like the one that's most in line with my values. Some aspects of what they call mental health first in Sacramento, I also think are good. But some of the stuff they say on their website is also very medical model. And even the terminology of mental health is not something I personally would be comfortable with. But I think we really just have to start doing it for ourselves, taking it into our own hands, and getting back to a sense of community for some people, the peer support community, a space like Peer Galaxy, that may be it for you. And you want to just keep putting your energy into that space and doing everything you can with it, publicizing it, getting more people to know about it and participate in it, and practicing real peer support. I think that there's a lot that can be done that way. It's not everything, but I think it can go a long way, and also creating, to keep creating and cultivating a sense of community that can also come into advocacy. So I'll just put in a little plug for my book, Reimagining Crisis Support, Matrix, Roadmap, and Policy, that you can get, everybody can get for free online. I am in process of working with a group on a Spanish translation that I have to get to my part of finishing my review of their translation, and so we can finalize that and make it available. But yeah, there's always more and more and more to talk about, but thank you all, because I see we've come to the end of our time. Thanks
Speaking of publicity, look at this fascinating Peer Galaxy time for summer. Laura Rose can hook you up. Thank you so much, Tina, and thank you for putting this on. Appreciate it.
Thank you very much, Tina, for being with us today. And by the way, everybody, we are going to be having 2 more programs with Tina in the month of July. And we'll be sending you the information on that so that you can come back and join us again. Tina, fascinating, good stuff.
I guess I just want to actually say, since I mentioned my book, that the next program on July 12th, I believe, is going to be to have a kind of question and answer session about the book. So if you all want to go to the website, download the book, you can be prepared, do some homework if you like, or just enjoy the book, or just come and listen and ask whatever questions occur to you. And then we're going to be, the one after that is going to be talking about reparations. So that's going to be maybe more intense, and, you know, be prepared to, you know, like that could be painful, but
That's where I've been doing some of my homework is on reparative justice, looking back and looking forward.
Awesome. That's great.
There's a lot there. There's so much to unpack. It's been a long history, but then what you bring to light and what's happening on the global scale is so important. So maybe we can carve a path.
Yeah. Thanks. I appreciate that optimism. I want to be there. Yes.
Well, thank you, everybody. Maybe what we should do for the next program is a lot more time. What do you think? For the discussion of the book, and when we get to reparation especially, we can talk about increasing the time so that we have more time to ask questions about, especially reparations around psychiatric torture in the US. Something's got to be done.
We can definitely talk about the timing and all of that, you know, and just make sure that if we increase the time for these, that we allow a break, because longer than 2 hours is hard for everybody.
Yeah. All right. Well, everybody, I'm going to be sending you, I've got everybody's email that posted in the chat. We will be forwarding you the slides from today, as well as the 2 dates for the forthcoming meetings with Tina. Thanks again.
Thank you. Bye.
Bye-bye. Bye-bye, everybody.
Thank you.
Thank you. See you soon, Tina. Ciao.
Thank you. Bye.
Ciao. Bye.